Hey there, it's Seb by the Realtor, and I just got done doing a webinar with Nicole Adkison. She is an amazing, dynamic estate planning attorney, and we talked all about estate planning, trusts and wills and probate and tax issues. Listen, if you have any kind of assets and or any kind of family, you want to protect both of those, and having a robust estate plan is the best way that you can do that. So please set aside a few minutes. I think this webinar runs somewhere around 40 minutes, give or take, and we have a very in-depth question and answer session with Nicole and myself, as well as with several people who are on the webinar who posed some very good questions as well. So without further ado, please sit back, relax, get ready to take some notes, and enjoy this presentation with Nicole Adkison. Nicole, do you want to introduce yourself?
Well, hi, I'm Nicole. I have a practice in Santa Cruz. I live in Montana. I am a giant geek about all things asset management. So, estate planning, tax planning. I've got a master's degree in tax law. I'm a certified legal specialist in taxation for the California Bar. And I love this stuff. So, there's no question too big, too small. I love them all.
All right, very good. And Nicole, do you have like a presentation that you want to run through real quick, and then we'll do like questions, or how did you want to work this?
Yep. Can you give me the ability to share my
Can I let
screen?
you share your screen? Let's see here. How can I do that? More. Let's see here. Allow. Let's see here. Make host. There we go. Okay, change host. Now I think. Can you share your screen now?
It looks like I can. Woo-hoo. Okay. Share.
Ah, there she
All
goes.
right. Can you guys see this?
Yep, I see it.
Okay. I can figure out how to minimize this little thing on the side. All right. So, as I mentioned, I'm a bit of a geek. I love this stuff. I find it fascinating. I talk to people about it all the time. So this is one of my favorite presentations because it kind of succinctly designs the importance of this is. So estate planning, asset protection, and charitable giving, how not to go to jail or bankrupt your heirs. And maybe it'll let me, so there we go. All right, so the basics. What is an estate plan? As the intro mentioned, there's loads of information you can find out there on what an estate plan is, but there's no real why does it do the things it does. So at its very core, an estate plan is a set of documents that governs what happens to you and your stuff when you're no longer around physically or mentally. This is a death and incapacity. I know, super fun topics. And this is how we move forward when something happens. So the core documents are a revocable trust, a pour-over will. A will comes in two forms. So a will can be either complex, which is what most people think of as a testamentary document, and it says, what you have and where you want it to go and who's going to be your executor. In California, we largely use trust to facilitate that because wills still have to go through the probate process. So in the case of using a trust as an estate plan comprehensive centerpiece, we get a pour-over will. And all that does is it grabs a missing asset. So if something doesn't get titled properly, it grabs it and puts it in your trust so that your trust is always the middle, the center bucket. So then it also has a power of attorney and a healthcare directive. Those two things together will keep you out of probate court for conservatorship. There are two types of conservatorship. There's the conservatorship of the person. That's who talks to the doctor in the event that you cannot. And there's a conservatorship of the estate. That's who handles all the money. And so a power of attorney will take care of the conservatorship of the estate. Healthcare directive takes care of the conservatorship of the person. We do an assignment of personal property that just says everything you own, all your stuff, the couch, the car, the cat, all belong to your trust, all belong as part of your estate plan. And then the certificate of trust is what allows you to retitle your assets. So the unique thing about using a trust as part of your estate plan versus a will is instead of having to go to the court and ask the court to say hominis dominus over your estate plan, a trust, when you create it, you execute the documents, and then you retitle your assets into the name of your trust when we do the plan. So it all happens currently. So when something happens, your successor trustee comes in and they do some paperwork and off they go. There's no court process required. It's a bit of an onerous mess to deal with when you have to retitle all your assets, but it is well worth the hassle. And the certificate of trust is what gets you there. So what happens when you don't plan? Probate. The number one thing I say in my office is probate is bad. Probate is time consuming, it's expensive, and it's public. The fees are calculated on the gross appraised value of the estate, not net. And so you can have $1 million house in Santa Cruz with a $950,000 mortgage. You're going to pay $60,000 in fees on $50,000 in equity. It's rough. Probate is bad. It takes forever. The court calendar has us out several months now. Before anyone can do anything, you have to have a PR appointed. It's a mess. So probate is bad. So please note my font there. All right. So the process, just in case you wondered, you petition the court, and then you have to publish notice to the creditors. We do that in the Santa Cruz Record. That's public. Then you have to send out notices to the heirs. Then your executor gets appointed. Then your executor has to marshal all the assets. Then you got to wait 120 days for the creditor claims. Then there's got to be an accounting, and then you petition the court for distribution. You got to pay your statutory fees. As you can see, it's a process, and it takes a year or so. And if anything goes wrong in the middle of that probate, like I have one going on now, one of my beneficiaries passed away in the middle of the probate, and we had to open up another probate inside the first probate to be able to close them out. So it is bad news bears. But I do happen to think that this meme is terribly funny. Okay, so what about taxes? Estate planning and tax planning go hand in hand, but they aren't necessarily the same thing. This is one of my very favorite quotes. I'm an estate planner and I'm a geek. The only difference between death and taxes is that death doesn't get worse every time Congress meets. A basic estate plan can't save you from paying estate taxes, but there's something called the applicable exclusion amount, and that's what the government says that you can pass tax-free. At the moment, that is $12.9 million, but that's going to sunset back down, and there's a slide on that in a minute, but that's going to sunset back down to $5 million index for inflation at the end of 2025. So as of January 1, 2026, that's going to revert back down to a smaller amount. There's also something called the annual gift tax exclusion. You're allowed to give away $17,000 to anybody and everybody you want over the course of a year without having to file a gift tax return, and that doesn't have any implication for your applicable exclusion amount, also known as the basic exclusion. Lawyers like to make things complicated. So advanced estate planning. There's a lot of things you can do if you have unusual situations. So if you've got a lot of money, there's a whole pile of things that we do. If you've got beneficiaries or heirs that have special needs, there's a whole way we go about protecting them. There's asset protection that goes into your revocable trust planning. So a revocable trust, remember, is the very basic of the estate plan. And that's pretty much what everybody should have. And so, but there's a whole lot of other planning. And what I always tell my clients is if you can dream it up, I can draft it. I have had some crazy ideas come through my office and I can incorporate them all. If you've got people that you want to disinherit, if you've got kids that are crazy, if you've got it's not even the kids, it's the people they marry. That's another big problem. So there's all sorts of things that you can do to guard against all the things that you want to guard against. And you can do that currently. So when you create your plan, you make all these decisions. And the best part of a revocable plan is that you can change it. You can change it whenever you want. We make amendments to it. We add things to it. We can create sub-trusts under it to facilitate all of your wishes. And the idea is that you make all the wishes and you make all the plans so that when something happens, your successor comes in, they do all the stuff that you told them to do. They don't really have any autonomy. They've got full discretion, and I'll discuss that later, but it's not anything that they have to make decisions on. You've already done all that work for them. All right, so This is what I was saying earlier. The applicable exclusion amount is currently $12.92 million. It's going to increase again over the next couple of years. Then it's going to go back down to 5 million index for inflation. My little crystal ball says it's going to be about 6.5. And these numbers are per person. So if you're married, it's $13 million. And this is, again, a rough estimate with inflation the way it is at the moment. Could be a little higher than that. But there's some advanced planning that needs to get done. And the important thing, or I guess the geeky thing, is that the IRS has issued final regulations that says that if you have all this money and you gift it out now, as long as you do it before the clawback period starts, and I'll save you the lecture on that, that the IRS will allow you to keep that high amount. So if you give out $13 million per person, the IRS will actually allow you to keep that, and they won't claw it back into your estate. So anyway, that's a I wish I had that problem, but I don't. But many of my clients do. Okay, so what happens if you have more than that? There's some really cool things we do. I do a lot of company formations. A lot of estate planners kind of avoid the business entity part of estate planning because it's a whole separate set of rules. But I have a degree in finance, and like I said, I have a master's degree in tax law, and I love business. Businesses are useful for retaining control, for divvying up assets. They're quite a gift, and I don't think they're used quite enough. But there's some charitable giving too, and that has its own special benefits. So the Internal Revenue Code incentivizes giving. So a charitable remainder trust, for example, it allows you to gift money out, and you get a current year tax charitable deduction. And then it allows you to take care of your heirs and benefit a charitable cause that you like. So, and there's a lot of tools in that bag, and I've set up many of them. They're really cool. All right. So that's my run through the presentation thing to kind of give you a global overview of the massive nerd that I am, I guess. Let's see if I could. Are we back? Did I get rid of my screen?
Well, I can see you. So I got a question. So you have the trust and then you have a pour over will. Why do you need a pour over will if you have a trust?
You are in real estate. So of all people, this is more in your arena. People do refinances. This is just one example. People do a refi. And so what happens is the lender, they won't deal with your property while it's in a trust. So they do something called a substitution of trustee. They pull it out of the trust. They do their thing. They put it back. They don't always put it back. So if your assets get missed, if something is supposed to be part of your trust, but like in the case of a refi and the title company doesn't put it back, the will acts as kind of a runaround to the probate process. So we do something called a Hegstad petition, and it just says we need an order confirming trust assets. So instead of going through the whole probate process, that whole public thing with 120 days and creditors and all that, the court just says, oh yeah, we can see by the paperwork that this was actually meant to be a trust asset. So that's what the will gets used for. Another common one is when the beneficiary of your IRA passes away before you do and you don't change your beneficiary designation. It'll wind up in probate court, and the Hegstad petition will grab it and put it in there.
Actually, I had to do a Hegstad petition one time. Very exciting stuff. The old
Oh boy,
Hegstad
let me tell you.
Yes, it was good. So who do most people choose to be their trustee or their executor?
So I actually have kind of a different viewpoint on this than some of my colleagues. I say it should be the person that's the fairest. So I can, and again, because I'm a big nerd, I can teach anybody what to do as successor trustee, what the process does, what your fiduciary obligations are. It's most of the time somebody will say, oh, appoint somebody in your family that has a degree in accounting or is financially savvy or something. And those are useful. But I have found in my practice in contentious trust administrations that the best people to act as trustee are the people that you trust and you know are going to be fair. So let's say your oldest son has a business degree. Cool. He's probably like well suited as he knows what a fiduciary obligation even is. But let's say the second one, the daughter, is the one that's like, okay, let's make sure everybody gets along. That's the person you want as your trustee.
Really? That's the person you want as your trustee, huh? Interesting. Do people ever hire like an attorney to be their trustee? Like if they don't feel they have anybody competent in their family or
Yes. So I act as trustee on a handful of trusts when it fits. There's private professional fiduciaries. We also have corporate trustees. So in my, I'm an oddball. So in my practice, I genuinely care about the relationships of my clients. And so oftentimes when I do like multi generations of families. And so oftentimes I know the family so well and I know their wishes and I know what they want. So they'll make me trustee. And it's mostly because it's just a neutral arbiter between people. Not that no one's going to get along. It's just, oh, I don't want to deal with it. Or, there's so many assets and it's so complicated that it's just easier to have a professional do it. A private professional fiduciary does the same thing I do. They're a little bit cheaper. Um, I have pluses and minuses to them. I enjoy working with them, but it's hard to get them to stick around. So if you need a successor trustee tomorrow, then perfect. You've got this person lined up. But if you name someone a successor trustee on a trust that's going to be administered 20 years from now, who knows where that person's going to be. I have a successor lined up. And so and on that note, a corporate trustee does exactly what's said in the documents. They're expensive, but they're neutral and they're hands off. They have no connection to your family. They don't care about the drama. They don't care about any of that. Pluses and minuses to that too. And they have a constant succession. So if you appoint, let's say Boston Private, which you're not going to do because they were owned by Silicon Valley Bank, but if you did, they have a successor and a successor and a successor. So if your trust goes into effect 30 years from now, there's somebody there on the line. So a corporate trustee is really good for longevity.
Yeah, so I've had a couple of times where like JP Morgan was like the trustee and stuff like that. So that's basically what that is. That's a private corporate trustee. And do you pay them like a retainer or like a monthly fee or a yearly fee, or how does that get structured? Any idea?
So they have a fee structure, and as soon as they go into effect is when they start charging you. And it's usually 1.5% of trust assets. I charge 1% to do trust administration at the beginning, and then I tend to charge hourly, unless you have crazy people in your family and they call my office every 45 minutes, which has happened before. I said that I'll charge 1% per year. But otherwise we do it on an hourly basis, because I do a lot of dynasty trusts. And so if you have a series of trusts set up to benefit your kids, which is a great asset protection tool, so oftentimes everybody gets along, they get their distributions, everybody's happy. It's just an accounting and a tax return. So there's nothing really to that. I think it's a waste of trust assets to charge the full amount. But the corporate trustee will charge, it's usually about 1.5%. There's no retainer at the beginning, so you can change your mind and appoint somebody else if you want. And that happens often. So sometimes people will put a corporate trustee in like when their kids are minors, and then they'll remove them and add their kids later once they become of age.
Well, could like a corporate trustee be like a successor trustee? For example, you have like is that normal? I mean, that seems like a good thing to do, because like you have like your trustee and your successor trustee, but a lot of times people are older. And so maybe you set up your trust 20 years ago and then the trustee and the successor trustee dies. What happens if the trustee dies and the successor trustee dies? What happens then if there's no trustees anymore of the trust?
If there's no more trustees, you have to go to court and have one appointed. But the caveat to that is if the beneficiaries all agree, they can appoint a corporate trustee without a court process.
Oh, okay. That's interesting. All right.
They can't appoint a private professional fiduciary or one of them. But if they do decide, let's say you have 4 kids and they all 4 of them agree that one of them should be successor trustee, they just petition the court and the court says hominis dominus and says, okay, you guys agreed to this, but it just has to be sanctioned. Otherwise the banks, and the reason is that the banks won't talk to you if there's not a court document in there that says, oh yes, this person has the authority to act.
So you've said now hominis dominus twice. First time I thought you were joking. What does it actually mean?
No, to be perfectly fair, one of my colleagues actually told me it doesn't mean what I think it does, but I always imagined it as like, bibbidi bobbidi boo.
Yes.
So that the court says, the court gives their blessing to whatever it is you decide.
Okay. All right. The court basically signs off and says, yeah, that's okay. Yep. So now, like, what do people do with all these like how do you let's say I imagine a lot of times there's a trust and nobody knows about it, right? So like where does this trust stuff get like left so that it can actually be invoked or whatever upon your passing?
Best advice I can give my clients and anyone looking to set up an estate plan, just tell someone where the binder is and who you work with. So put my card on the refrigerator if it's me. or your estate planner. Just put it wherever your important stuff is. Let somebody know. And then if they can't find your trust binder, if for some reason it's gotten stuck on a shelf somewhere, we actually had one go through probate, an entire probate process, and someone found the trust binder at the very end, at the bottom, underneath a bunch of stuff in a closet. So if they can't find it, though, my office always keeps a copy. And when you do an estate plan, we give you a full digital copy. But on that note, do not give that out. We do not want anyone, no one should see it. I mean, it happens sometimes. People are like, oh yeah, I absolutely want my kids to have this, but you can change your mind. It's revocable. And heaven forbid we take 10% and give it to the grandkids and take money out of the kids' pockets, because that has become quite a thing. Plus rugs, whatever rugs you have, please distribute them before you're gone, because I swear, of all the tangible personal property, rugs seem to cause us the most heartache.
Interesting. So when you put your property into a trust, it says, like now so-and-so trust, right? And sometimes I think the trust gets recorded, the actual trust documents themselves. Is that correct? Or am I imagining that?
So that does happen in other states. Like Colorado requires that you record a revocable trust. California does not. That's one of the few things they actually get right. But they take privacy very seriously. And so sometimes, though, if you have to go through a court process and there's some kind of fight between the beneficiaries, the trust gets recorded by way of the probate process. But yeah, your transfer of title is the only public part of it. So, you create the Frey family trust, and your assets will all be titled, Seb Frey, trustee of the Seb Frey family trust. And that's what the public notice.
So if, let's just say it's in a trust and that it's like the actual title says, Joe Blow Family Trust, then and then the person passes away and no one can find the trust, the actual documents, no one has any idea, what do you do then?
Well, somebody usually knows something about where you had the estate plan done. And estate planners tend to be older folks. There's actually in Santa Cruz, I'm one of the younger ones, but there seem to have cropped up several like younger ones lately, which is awesome. Because they've been like in their 70s. But Santa Cruz especially is a small town, and it's pretty easy to figure out where someone had their documents done. If someone retires and they don't get their file back, they can contact the California bar, because as estate planners, unlike every other legal practice, if I decide to close my doors tomorrow, I have to return your file to you, or if I can't find the person, I have to turn the file over to the Secretary of State, so that there's always a record of where those documents are.
Oh, okay. So if that happens, ask the Secretary of State. They may have a copy.
They might, yeah. So if there's one that's just absolutely missing and no one can track down any information, I mean, I've actually called estate planners. I think I've called everyone in town just trying to find trusts every once in a while, and invariably someone has it.
Interesting. Okay. So just call up a bunch of estate planners in the area, or contact the Secretary of State.
Yep.
Okay. So how about
State bar?
I'm sorry, the State Bar.
Yeah, I'm sorry. It was this
Not the Secretary of State.
California
Bar.
State Bar. Yeah.
Okay. All right. So does the trust protect your assets from creditors at all? No.
One question I get asked: a revocable trust, there is no difference between you and it. So it's like a pass through, like an LLC or an S corp. There's no difference between you and it, and so it has no asset protection whatsoever. But what we can do, I mean, there are other ways we can do asset protection, but what we can do is, I remember that thing I said about business entities being very useful. That's one of those. But we build in asset protection sub-trusts into your revocable trust, so that when everything that you have passes to the next generation, because your heirs or your beneficiaries have never had control of those assets, if you create a bubble around them through an irrevocable trust, that provides asset protection for the next generation. And it's almost a matter of course that I build them into almost everybody's plans, because it's just such a nifty, useful tool. And we can make them discretionary. So if all the heirs are like, ugh, this is a pain in the butt, we can get rid of it. But so often it's just, and it's not even, we always think of substance abuse or poor money management, and those are some things. But oftentimes one of your kids wants to go into litigation or wants to have a startup company, which have high risk. And we don't want your assets that you've left behind being touched by creditors or predators. Sometimes it's the ex-spouses. Remember, I told you the number one reason I create asset protection plans is because mom doesn't like who Susie married. So
When you have a probate going, like you have 120 days for creditors to file a claim with the probate court. How does that work if it's in a trust? Because if it's in a trust, it's not going to go to probate court, right?
right. So when you have, so most of the time we know who your creditors are and they get paid during the trust administration process. If there's credit card bills or whatever, we have to do one of the things as trust administration, we have to alert Medicare or Medi-Cal to see if there's any claim there. But if a creditor exists and there's a trust in place and nobody knows they exist, they have a year from date of death to file a claim against the trust. And if not, then they're SOL.
Huh. Interesting. They have 1 year, and then if they don't file a claim, and then what if like there's like a year has gone by and the money was already sent out to all the beneficiaries? Are the beneficiaries on the hook for that, or?
Yeah. And that's in the final distribution notice. When we send out all the money, we say, look, creditors have up to a year to file this claim. And if they do, then it can be clawed back out of your distribution. So, and like I said, most of the time we know who the creditors are. It's rare that anyone just pops up out of the nowhere, but it does. I mean, it has happened, but it's not very often.
Okay. So when people put their trust together, like is it usually just mom and pop get together, or do they involve the whole family in this, or how do all these things actually get put together?
So it's mom and dad that come in and make the trust. But I always counsel my clients, my parents' generation, talking about money was taboo. And so it's not something we ever discussed. But now it makes so much more sense to have a conversation about what's going to happen, just because it seems to preclude conflict later. Now, sometimes, like I said, I do generations. I have grandma and grandpa and mom and dad and all of their kids. And so oftentimes it is helpful to have the whole family come in. We do big family meetings, and we have a conversation about what the plan is and how it's designed, so that everybody knows what's happening and is on board. So there's no conflict later, because I am a firm believer in transparency. I hate litigation. I think it's a waste of time and money. It causes heartache for the beneficiaries. It's exceedingly expensive, and nobody wins but the lawyers.
Okay. All right. Now, do I actually need to hire an attorney to put the trust together? Because I know you can go to like trust.com or whatever and get it done online. No, what?
Here's the thing. I admire all DIY stuff. I am a DIY kind of person. This is not the DIY arena. And I have this spectacular story. I have a client lived up in Aptos, and her next door neighbor used LegalZoom. And her house was worth $2 million or something. It's in Aptos. House was worth a couple $1 million. She had about $1 million in stocks and bank accounts. And so her total asset value was about $3 million. And she had a cat. And she decided to leave $10,000 to this cat. And she had a son. She was a widow. So just son and cat. So cat and its benefactor got $10,000, was not the son. The rest of everything went to the son, no problem. So my client was like, just go have she doesn't charge, just have her go take a look and make sure it actually says what you want it to. So this little old lady, she comes into my office and she's sitting at my table. And I'm scanning through this thing. LegalZoom documents aren't very complicated. So I'm scanning through this thing. She's like, do you think I left too much money to the cat? And I'm like, well, $3 million is an awful lot of money to leave to a cat. She'd gotten it backwards. And so she was leaving $3 million essentially to the cat and $10,000 to her son. So yes, be a professional. Do not use LegalZoom.
Yeah, actually, I had a couple of clients who actually did that. They went and they got, I don't know if it was LegalZoom, but somehow they got these trust documents. I mean, and they were like Word documents, and they just put them together themselves, and they were screwed up, and they had to go for those Hagstead petitions, right? Because they didn't do the trust right, and it was very stressful, and
Expensive, it's just time consuming
yeah.
and
Then they had to pay a bunch of money to an attorney to get it sorted out in a Higgs petition, much more than a trust would have cost.
right. And
So
then they
what?
have to have us administered anyway. They're still got to go through the process.
Right. And so, like, what does it cost to have like an estate plan put together, sort of ballpark? I guess everyone's situation is different, but what does that cost?
Yeah. So I charge for a very basic single estate plan. It's $2,500 for a basic couple estate plan. It's 4,000, and that is the trust, the pour over wills, the powers of attorney. That also includes the first deed to your primary residence. Every deed after that is $200 because of California's lovely SB2 fee, which adds a whole bunch of money onto your recording fees. And then if there's complicated situations, then it just goes up from there. But the basics. 2,500 for a single, 4,000 for a couple.
Okay, now that might sound like a bunch of money, but at the beginning of this, you mentioned that the probate fees are statutory. That means they're not negotiable, right? And you said they're between 5 and 10% of the value of the estate. Is that right?
That's right. And they're, like I said, they're valued on the gross estate. It's not even on the net estate. Like I said, you can have $1 million house with a $950,000 mortgage. You're going to pay $60,000 in fees on $50,000 in equity. It's absolutely ridiculous.
Right. Yeah. Okay. Now we have a question, I guess, here from Marcia, and Marcia is muted. I think Marcia, you can unmute yourself. Can you try unmuting yourself? There you go. Marcia, you have a question?
I'm sorry, I kind of came in about 3 minutes after it started, so I didn't really get. I'm just from my notes since then. I'm gathering that, and Nicole, you are an attorney, and you're located in maybe Santa Cruz.
Yep. I might have a primary office in Santa Cruz. I practice all over the state, but I live up in Montana.
Oh, you live in Montana. Okay. Now, how would I reach you? Can I have a phone number?
Oh, yeah. My office number is 831-426-1482. Probably should have had that on a slide.
I'll put that.
Is that Mountain Time?
No, that's my California office number.
Oh, that's the California time. So you're on that specific time that you would be.
Yep. Yeah, and I do almost everything on Pacific time. I'm in Mountain Standard, but my calendar stays in Pacific time. I have an assistant. Her name is Melanie. She runs my practice. I'm basically the lawyer. I show up, I do legal things, and then she does all of the rest of it. And she's in my office all the time. So she's there Monday through Thursday at my physical location in Santa Cruz.
So she could
receive. So if being that you indicated earlier that you do operate as a single, that you have a successor lined up. Yeah. Okay. And Sebastian, can I just ask you who you are?
Oh, I'm just a realtor here in town, just a normal, ordinary.
Oh, you're a realtor. You're a realtor where?
Well, I live in Aptos. My office is in Los Gatos, and I practice in Santa Clara, Santa Cruz, and Monterey County primarily.
Okay, so more South Bay area.
South Bay area, that's right.
Okay. Would you handle something in the closer to San Francisco, like Oakland property? Would you?
Well, I wouldn't rule it out. I'm from Berkeley, and so I consider myself an East Bay person, at my heart. And I've sold real estate as far away as Sacramento and San Francisco, so I wouldn't rule it out.
Oh, fantastic. Could I have your phone number?
Yeah, my number is 408-548-7348.
Thank you. I'll be calling both of you when I don't want to interrupt anymore, but thank you. I wanted to kind of just get an identity and get how I can contact you, because these are all things I need.
Terrific.
Okay, thank you.
Okay, thank you, Marcia. And we had a question here from I think it's Jennifer about do you take insurance to do will and trust? I'm not sure what that means. What does that mean, Jennifer? Do you take insurance to do will and trust? Jennifer still around? Yeah.
I have I'm an ROG member, so that's one of the legal insurance companies. I don't do Hyatt. I'm an ROG member because I have clients up at the UC, and the UC offers ARAG benefits. And so yes, I will do them. I just kindly ask that anybody that is associated with that just remember that I don't. It's not like an entitlement through the university. It's, I'm a lawyer just facilitating things. Because some people are like, oh, well, I mean, I have this benefit, so you have to work with me. And I'm like, that's not the process.
So this isn't so, I've heard of like these like retainers, like you pay like lawyers.com or whatever, $100 a month to have like on-demand legal help. So what is this? This is like an insurance. You can buy like legal insurance to pay for this kind of stuff.
Yep, it's offered through the UC. I have clients from Dominican. I'm not sure who else. I think there's like a couple of the state agencies. It's like a health insurance benefit, but it's legal insurance instead. And they do one of the things I do with it more often than estate plans. They have a really cool benefit to have an attorney help you through a real estate closing. And so I'll review the contracts. It just make people feel better because, when you buy a house, as buyers are like, oh my gosh, what am I doing? This is a huge purchase. It's a big deal. And so to have someone kind of just run them through and then I'm able to say, okay, well, if you have a trust in place, you're going to take title this way. If you don't have a trust in place, here's what you should do, and then create a trust. So it's a nifty little benefit through ARC.
Yeah, that's interesting. I did not really, I've never heard about that before. That's terrific. So great. And Cheryl is asking if we can repeat our names and contact info. So Nicole, can you tell us your name again and your contact info?
Yep. So it's Nicole Adkison, Adkison. And my office phone number is 831-426-1482. And my email address, which is a good way to get a hold of me, is Nicole, Nicole, at adkisonlaw.com. So ADKISONLAW.com. And I'll put it in the chat.
And you have an office in Santa Cruz where people they want to mail something or drop something off. You have somebody there during normal business hours to take documents and whatever else may be needed. And my name is Sebastian Fry, and you can see here, sebfry.com is my website. And can you read that? Yeah, sebfry, SEBFREY.com. And my email is sebfry@sebfry.com or 408-548-7348. And this will become a video, and I'll put it on my YouTube channel, and I'll send it to everybody who signed up, and that will all be on there and in the notes on YouTube. So let's see here. Do we have any more questions from anybody else here for Nicole? Anything at all? I think Nicole, you know more than just about trust and estates, right? Don't you know about all kinds of very important legal things?
Oh boy.
I refer everybody to Nicole basically is whenever anybody says, do I need an attorney? I said, just call Nicole first.
Just call me also.
Just call Nicole first, and then if she can't help you, I'm sure she knows somebody who can. So all right. Well, I just want to say how important it is, because that probate really is a nasty thing, and that for me, there's two things that come up for me why I think it's important to have the estate plan. Is one is the probate, because the fees are so expensive. I mean, we're talking tens of thousands of dollars here. And then also if you have any kids, right? I mean, if you have no kids and you have kids and you don't have a will, the kids get taken away.
Yeah, it's bad. So that's one of the main things of estate planning, especially if you have minor children. If you don't have something in place, if you don't have guardianship papers in place and temporary care provisions in place, your kids get taken to the state. Like they get taken into foster care until someone can come claim them and the court can say, oh yes, these people are actually legally entitled to take them. It's horrible. So that
can take months, right? Or how long does that take?
I mean, they try to do it as quickly as possible, but if something happens to you, your kids are in absolute chaos. They're grieving. They've lost their parents. They've now awarded the state. Yeah, it's a nightmare. So if you have paperwork in place, it's just easy transition. And sometimes
if you don't, even if you have like parents or siblings, they don't get them.
Right. The court has to say, oh yes, these people are in fact entitled to, and the foster care system, they bless California. They try to make it not so bad, and they'll allow temporary custody of someone like a parent or a sibling or something. But it's certainly not guaranteed, and it's a nasty process.
nasty process. So very, very important to get this done. Well, Nicole, I guess there are no more questions, and so I just want to thank you so much for your time. And we will have this available as a YouTube video for anyone to go and look at later.
And thank you so much for inviting me to do this. One thing I will say about estate planning, unlike other areas of the law, are that, estate planners, we know your family drama, we know your finances, we know all of the quirks and ins and outs, and we're not all created the same. So I'm a very relationship focused person, but I'm not a typical attorney. I'm not formal or stuffy. I will often draft your documents before you've signed a client engagement letter. It's just, I have a 99.9% conversion rate because it's all word of mouth. People come into my office from people I know and trust, but I'm not for everybody. And so look into the person that fits for your family, because if you find a good person, it's a lifetime relationship. We're going to know you and your grandkids and when your dog dies. And my clients are, I invite them for wine tastings and taco trucks and all sorts of fun stuff, just because I want instead of being a pile of documents that just shove on a shelf somewhere and forget about for 20 years, I want it to be kind of a dynamic thing that, there's this thing in the background protecting your family. So, like I said, if you're interested in doing an estate plan, or someone who is, just do a little bit of I don't want to say research, but just kind of test it out.
Due diligence. Yeah. Right. Make
Hello?
some inquiries.
Right.
Hello, I'd like to ask a question.
Okay.
Oh, sure. Go ahead.
Sorry I waited so long. My name is Jack. My wife has 3 sisters, and one of the older sisters currently lives in Bangkok. And she has a condominium here that is rented out.
Huh?
And the money gets deposited automatically by the tenant into an account.
Mhm.
My wife transfers the money to Bangkok for her older sister.
I have the power of attorney on that account.
My wife has power of attorney on that account. So I'm a little concerned that we might get caught up in a tax issue because my wife is on the checking account and does the transfer of the money to Thailand. I don't want it to look like it's an income that my wife and I have. What is the risk that we have there? And the older sister, if she passes away, she has
there's a
bank that's supposedly going to take care of this stuff, but I'm concerned that she should have a lawyer in California writing this thing up.
Yeah. I'm sorry.
I'm done.
Okay. Yeah. So that can be kind of complicated, but there's a whole bunch of things that are surrounded. So is there a document, like a trust that was set up or something that is being facilitated this way? Or are you just gifting money to the sister?
Well,
It's a will.
Okay. So you were the executor for it?
no, her oldest daughter is in Bangkok living with her. She's the executor. I manage the estate here.
Oh,
I just manage one property here,
Got
and have a joint account with her that I send her monthly income.
yeah.
But-
So no, there's not going to be a tax implication for you, but there is. The foreign tax rules are complicated, and that's being very kind about it. And every situation is very unique. I would obviously be happy to take a look at the actual situation. But as long as it's being facilitated pursuant to a plan that was in existence,
There's no plan.
it's just off it goes, huh? There should be a plan put in place.
My sister should be putting a plan in place, and I just, if she doesn't sell the property, I'm thinking she should either put in a trust with a trustee to take care of it. And
Yeah, 'cause otherwise it's going through probate.
exactly. Well, the will is, well, no, she has the will in time. Otherwise, it's going to go into probate, you said?
Yeah, in California, if it's not named in a trust, that doesn't matter what else is going on. California real property has to be named in a trust or it goes into probate period.
Even if you have a will.
Even if you have a will. Yeah.
We may be talking to you. Okay, thank you.
Yeah.
You don't feel that we have any risk of it looking like income for my wife and I?
No. I mean, again, I'd have to see the particulars, but no, I don't feel like that's much of an issue.
Okay.
Okay, good.
I mean, if anything else, you could just say it's a gift.
Yeah, exactly.
No, but that doesn't really work because if it comes into an account that's in my wife's and her sister's name, that's income, that's taxable. So if we gift it to her older sister, we still have to pay taxes on it.
Her money, yeah.
It's her money,
I'm just
right?
facilitating it.
But
My
yeah,
wife's
it's
facilitating.
pursuant to a separate document. So there's an easy argument to be had that, but again, it would be better if you put a plan in place that made that a little bit more clear.
That's what I'm
No
gonna
one
be.
wants to come up on audit.
Right, exactly.
Well, Nicole, speaking of that, I mean, what are the intra-family gift limits? Aren't they very high? I mean, you can gift a lot of money to your relatives without any taxation, any tax consequences. Is that correct or not correct?
Yeah, so there's two parts to tax, right? There's the income tax, which is what Jack's talking about. That's the money that your asset makes. And then there's the gift thing. So you've got two parts to the gift. There's $17,000 that you can give per year without a gift tax implication at all. And then there's the $12.9 million that you can give away during your lifetime under what's called a unified credit. And you have to file the gift tax return for anything over 17,000. But I can see that the concern would be, you've got this property that is owned and that's making money. So we don't want it to be considered income. So that, I mean, it's a real possibility, and I'd have to see the particulars to give you a better answer.
Okay.
Yeah, because I have a lot of clients who gift to their kids hundreds of thousands of dollars for down payments, and no one ever pays tax on it.
Yep, that's right. So you file a 709 gift tax return, and essentially that's what allows the IRS to keep track of all the money you give out during your lifetime. And no, there is no tax implication to the donor or the donee.
Right. So when we're talking about family, is this like brother to sister, like
You
parent?
can give out to whomever. It's not a family thing.
Oh, it's not a family thing. You can give.
No, you're allowed to give away $12.92 million during your lifetime to whomever the heck you want. Your cat, in fact.
I'm concerned about this income, which is over $2,000 a month, which
Yep.
only over $24,000 a year. The income, though, looking like income for Cheryl and I.
Yeah,
I don't.
I
It's
can
not.
see
We never. But she's on. My wife is on the checking account with her older sister, and so geez, I just don't want it to look like income. Why should I pay tax on something that we didn't get?
I'm not.
What?
Yeah, so if it's whoever's name is on title is who makes the income.
Right.
Not whose name's on the bank account.
Yeah.
Okay, very good.
Okay, she just needs to get a trust in California, and that's all I need to tell. That's all. Otherwise, it goes into probate. She says, "Oh no, it'll be easy." I'm like, no.
Something called a transfer on death deed, though. I wouldn't recommend it. Marcia, I'm sorry, do you have another question?
Oh, speaking of TODs, transfer on debt. In 2016, from what I recall, and so I actually have changed my real estate to that, is that California now allows you to do a TOD on your real estate as long as it's recorded into the recorder's office, wherever the property is. Yes. So that's something that, if you don't really need a trust for any other reason, that's another method of getting your real estate.
Yeah. So TODs, I don't like them because they fail too often and then they end up in probate. So it's not, but it is much more cost effective than setting up a trust if you don't need anything else. If you already have a power of attorney and all that.
I just wanted to throw that in there because a lot of people aren't aware of that law got changed in 2016.
Yeah. The TODs are, in fact, I've done two of them the last week, oddly, because I don't hardly ever do them. But if the beneficiary passes away before you do and you don't change it, that's when the trouble begins. And that has happened on a number of occasions. But they are there. It's a cost-effective tool to pass real estate outside of a trust.
And avoid probate.
And avoid probate. Yes, that's all of the things. Probate is bad. I need like a moniker. Probate is bad. I need to forget.
Prior to 2016, I was having stuff go in and out of those, because they refi and they don't let you, you got to put in and out of the trust. And finally I said, oh my God, they finally did something about this,
Yeah.
So even though I have a trust, I still, I put it into the TOD so I don't have to keep doing that.
Yeah, I would strongly, especially if you've already got a trust set up, I would recommend the hassle and have your trust dictate everything, because That
Well, I
allows,
don't want, I actually do not want the trustees to have my real estate anymore. So there was another method to my madness. They've got enough already. Do you know what I mean?
yeah,
But we'll chat, because everybody's situation is,
Yeah.
particular to, and so I am going to be giving you a call in addition to Sebastian.
okay. I'm happy to chat.
Great.
Anybody else? Come on now, we've opened up the floor. Like, I love questions. Come on, bring it up. I'm sitting here. I'm ready with answers. Nothing?
People are shy. I understand.
Wow.
All right.
Well, I could actually present my situation that I have that's a real estate question, and maybe Sebastian or Nicole can tell me whether, direct me at least. So I have a couple of promissory notes that were made by a broker that was referred to me years ago by my CPA at the time. The broker died. And unfortunately, he does not have a real backup plan, it seemed, and that he always insisted on keeping the original documents, et cetera, but there was no one to replace him and take over. So basically what he was doing was brokering second mortgages. So I have two promissory notes. There are now 11 years in arrear. And one of them is still paying the interest. The other one has not paid any interest for 11 years. And they're both, I have the deeds of trust. I have the original promissory notes that they turned over to me when he died. And I have not found a solution for being able to collect on the promissory notes that are 11 years overdue.
And you've got a deed of trust.
But I'm on it's a secondary mortgage.
You still have, well, I guess it depends on what your deed of trust says, but normally you still have the right to force the sale.
But then I'd have to pay for the first mortgage, which I probably wouldn't be able to do because this is, in the Bay Area. So can I pay off the first mortgage? Probably not. But
no.
I know that they can't close on that escrow, but I've been waiting for them to try to resell it or do something so that they have to come to me. But that's not happened. And now it's going on over 11 years.
Well, if you go into a foreclosure process, the house gets sold as the foreclosure process. First and second get paid off.
Oh, that's what I need help with then. Thank you. So who should I call? You, Sebastian, or Nicole?
Nicole.
Thank you.
Yeah, Nicole would help you with the foreclosure process, right, Nicole? You can help her foreclose on the property.
I've done a few of them.
Okay, so good. I just thank you. Maybe I'm going to get all of the things I need in one place.
Yeah. Great. If it's an asset, I know what to do with it. If it's a personal problem, maybe not my speed.
I promise you, I won't take. Well, we'll just discuss them, but I don't expect you to resolve them. I like your relationship attitude. That's the way I like doing business. I like establishing relationships.
Me too. And because of it, I have a great referral network. So my clients come to me for everything from caterers to zoo recommendations, and I got a guy. So
fantastic.
I have a question about the last person's issue. If the promissory notes are being held by you, and the people who are supposed to pay them, are they tenants? Do they actually live on the properties?
They own the real estate. No, they don't necessarily live on the property, but they own the real estate. The ones that have signed those promissory notes. Yeah.
Okay. All right.
And if there's tenants in those properties, that gets a little sticky, but it's easy to deal with.
Okay.
A little bit of both between the two of them. But like I said, one of them has been paying me interest at least. The other one, I would say the interest has accumulated up to $84,000 just for the interest.
Yeah, and the enforcement mechanism is inside the promissory note and deed of trust. So whoever drafted it is, this is what happens in the event of a default.
Yeah, it's all been legally done and by the title companies and everything like that. Nothing was done, and so it's just that I haven't been able to find anybody to help me.
Well, I think
now I have.
Well, you found her now.
That's
yes. Thank you.
Anybody else?
All right. Well, any other questions? Going once, going twice. No more questions. All right. Nicole, thank you so much. I really appreciate it. I will make this available on YouTube in the next day or two, and everyone can watch the replay, and we'll find all the contact info for Nicole and myself on the video. And thank you all for coming today. I really appreciate it. And Nicole, thank you so much for making the time available.